The glorious British Columbia housing market. It's the one place on earth where we can reliably turn a housing crisis into a multi-billion-dollar, constitutional, legal horror show. Because why simply build homes when you can instead have the province's highest courts declare the core assumption of property ownership, your fee simple title, to be utterly defective and invalid? We're not just talking about bureaucratic red tape here. We're talking about an obscure legal decision from August that wiped out 29% of one man's equity in a single transaction, followed by a catastrophic December ruling that just handed judges the ultimate veto power over every single law the province has ever passed. Right now, as you watch this video, up to 15,000 future homes across British Columbia, projects meant to shelter families and stabilize the market, are officially sitting in legal purgatory. Wait. What? I know that number sounds insane, but stick with me because the math is terrifyingly simple. If you're invested in BC real estate, planning to buy, or just hoping to afford a roof over your head, you need to understand the new, chilling reality. Before we dive into the total financial and legal destruction underway, do me a huge favor. If you've ever felt that the property market operates on borrowed time and shaky ground, and honestly, who hasn't, hit that subscribe button now. This channel is dedicated to cutting through the noise and giving you the unvarnished truth about what's really happening to your investments, and trust me, you'll want to be here as this constitutional train wreck unfolds. The moment that seismic shift hit the market was August 7, 2025. That date delivered the first of our two catastrophic court rulings, this one courtesy of the BC Supreme Court. The Cowichan tribe's case declared Aboriginal title over a massive 732-acre parcel in a specific area of southeast Richmond. The magnitude of this cannot be overstated. For the first time in Canadian legal history, a court recognized Aboriginal title on land that included fee simple private ownership. This is the gold standard of ownership, the type of title your bank relies on for your mortgage, and the type of certainty that underpins the entire modern economy. Justice Barbara Young's judgment didn't mince words, calling existing government fee simple titles in the area defective and invalid. The court didn't just question the ownership, it effectively pulled the rug out from under the legal foundation of the land itself. The judge provided an 18-month window for all parties, the First Nation, the province, and the city, to negotiate a path forward before the implementation order takes effect. This was a Hail Mary pass to avoid immediate chaos, but the market's reaction was swift, brutal, and immediate. Uncertainty is a financial contagion, and it spread faster than any virus. Richmond city officials had to send notification letters to roughly 150 property owners in the affected zone, essentially telling them, your ownership is now subject to constitutional debate. The results were devastatingly real. Consider one listed property that had an asking price of $900,000. Post-ruling, it sold for $700,000, which is an immediate, forced equity loss of $200,000 and a staggering 29% price collapse, all due to title uncertainty. This wasn't a market correction, this was legal uncertainty destroying asset value overnight. But the real damage wasn't limited to a few private home sales. Think bigger. A fully approved, shovel-ready, $100 million industrial development was torpedoed. A Richmond city councillor confirmed that a major financial institution, a bank, pulled the entire construction loan. This wasn't some speculative venture on a drawing board, this project had its permits, its approvals, and its contract signed. The bank's reasoning was simple: the Aboriginal title ruling injected an unacceptable level of risk into the financing structure. If a fully de-risked, $100 million project cannot secure capital because of a new legal question about land title, what does that mean for the thousands of smaller residential and commercial projects that BC desperately needs to address its housing shortage? The answer is obvious: they stop. Lenders across the province are now adding new, costly layers of due diligence, or simply backing away from areas they perceive as legally questionable, effectively choking the capital pipeline that fuels all construction. This August ruling didn't just affect Richmond, it was a shot fired across the bow of every single BC property owner and developer. It established a dangerous new precedent: your property rights are no longer superior to Aboriginal title. The shockwaves are still reverberating. While the Richmond ruling felt like an earthquake in one localized area, the decision that followed in December was a constitutional tsunami that affected every square inch of British Columbia. On December 5, the BC Court of Appeal handed down a 2-to-1 majority decision in the Jishala Nation case that dramatically redefined the power of the Declaration on the Rights of Indigenous Peoples Act, or DRIPA. In one swift stroke, the court shattered the long-held assumption that DRIPA was merely a policy guide, a nice-to-have political statement. Writing for the majority, Justice Gail Dixon declared that the law now incorporates the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP, directly into provincial law with immediate legal effect. The game-changing phrase from the judgment? UNDRIP now functions as the interpretive lens through which all British Columbia laws must be viewed and measured. Think about that for a moment. Every single provincial statute, every piece of regulation, every permit approval, and every development application must now pass a judge's review for consistency with UNDRIP. The specific target of this ruling was the province's antiquated mineral tenure system, which the court found was inconsistent with Article 32 of UNDRIP. That article essentially requires the free, prior, and informed consent (FPIC) of Indigenous peoples before any major resource projects proceed on their traditional lands. The court ruled that the old system, which allowed resource claims to be filed automatically without consultation, was fundamentally broken under the new interpretive standard. Braden McMillan of the Business Council of BC immediately expressed that the decision was deeply concerning to the business community, and while that might sound like standard corporate panic, it translates directly into real estate pain. Why? Because the investment climate is what funds the housing pipeline. If pension funds, international investors, and major banks perceive BC as a volatile jurisdiction where all laws and permits are subject to post-facto legal challenges under an expansive new constitutional framework, they withdraw their capital. This decision doesn't just affect mining, it affects forestry, energy projects, and, crucially, real estate development. Any project that requires a provincial law or regulation for its approval, which is all of them, is now potentially vulnerable to a legal challenge arguing that the underlying law failed to meet the UNDRIP standard. The previous ruling in August tied one hand behind the development industry's back, the December ruling tied the other, essentially making the entire province a legal minefield. We are now in a situation where the judiciary, through its interpretation of DRIPA, is effectively rewriting the rules for economic development in BC. The decision explicitly overturned a prior 2023 Supreme Court ruling that said DRIPA was not enforceable by the courts, instantly transforming a philosophical commitment into a powerful, litigious legal tool, and that is why the development and financial worlds are reeling. To understand why British Columbia is uniquely exposed to these dual legal crises, you have to look at its history. An astounding 95% of the province qualifies as unceded territory. That means, unlike most of the rest of Canada, Aboriginal title was never legally addressed or extinguished through formal, historical treaties. The few treaties that exist, the Douglas Treaties on a sliver of Vancouver Island and the adhesion to Treaty 8 in the northeast, cover only a tiny fraction of the landmass. The vast, overwhelming majority of BC's land, including the dense population centres of the Lower Mainland, has never had its underlying title formally surrendered to the Crown. This historical anomaly means that every successful Aboriginal title claim and every expansive interpretation of Indigenous rights law has a colossal, province-wide impact. It creates an enormous target-rich environment for future litigation, putting nearly every private and commercial land holding into a state of potential legal question. This constitutional crisis naturally puts the government in an impossible bind, and the Premier's statements following the rulings reveal their deep-seated dilemma. When the DRIPA ruling came down in December, his response was telling. He expressed a desire to amend the legislation to provide clarity around what was originally intended, stating emphatically that it is absolutely crucial that British Columbians through their elected representatives remain in control of this process, not the courts. This highlights the core tension at the heart of the matter: who ultimately holds the power to shape the province's future, the democratically elected legislature or the appointed judicial branch? The dissent from Justice Riley in the DRIPA case echoed this concern, arguing that the court was not invited or called upon to adjudicate claims of inconsistency and was acting outside of its proper role. Compare that to the Premier's response to the Cowichan ruling in October. He focused intensely on the practicalities, emphasizing that owning private property with clear title is key to borrowing for a mortgage, economic certainty, and the real estate market. Notice the language: mortgage access, economic certainty, market stability. He's speaking directly to the fundamental mechanisms of the modern economy that are now at risk. If your property title is deemed uncertain, your property becomes illiquid. You can't secure a mortgage, meaning prospective buyers can't finance a purchase, which in turn traps your equity. If this legal uncertainty continues to delay and kill construction projects, the housing supply contracts, and prices rise for everyone else, even far outside the affected zones. DRIPA was passed with unanimous support in 2019, with the simple goal of aligning BC laws with UNDRIP over time. But the Court of Appeal's recent decision accelerated that timeline from a legislative 5-year process to an immediate, court-enforced reality, forcing a constitutional showdown that now threatens to halt the province's development engine and reshape the very concept of property ownership. For property investors and developers, these abstract legal debates have concrete, painful consequences. The estimated 14,000 to 15,000 housing units currently frozen or at high risk are not hypothetical, they are the direct result of financing drying up and legal challenges being filed. Projects, like the proposed hotel in southeast Richmond and the critical Triangle Road Transit Infrastructure Link, are now on hold, representing not just lost housing units but lost jobs and stalled infrastructure. The government's own numbers show the massive scale of the pipeline risk. Vancouver alone has approximately 58,100 housing units in its development pipeline. The urgent question is, how many of those thousands of projects now sit on land where Aboriginal title could be claimed, or in areas where Indigenous consent was not obtained under the new, expansive DRIPA interpretation? Without government analysis, nobody knows, and that uncertainty is poison for the market. From the Indigenous perspective, however, these rulings are a long overdue correction of historical injustice. As Chief Counsellor Linda Innes stated, the colonial mineral tenure regime was violating their own laws, and the BC Assembly of First Nations has affirmed that the province must honour its legally binding commitment to the Declaration Act. The legal progression is clear and matters intensely for real estate. Delgamuqua, 1997, established Aboriginal title exists. Silcotin, 2014, became the first declaration of title over a large tract of land, and Cowichan, 2025, became the first to declare title over fee simple private property. This shows a steady, increasing willingness by the courts to prioritize Aboriginal title, even at the expense of established private ownership. For you, the property owner or potential buyer, the moral argument is irrelevant, the financial risk is everything. The 18-month negotiation window for the Cowichan case expires in February 2027. If negotiations fail, the question becomes, do those 150 property owners in Richmond lose their homes? Who compensates them, and at what valuation? The market's 29% value drop is the price of that unknown future. Furthermore, your standard title insurance policy, which you rely on for protection, typically contains exclusions for changes in law or government action. If a court declares Aboriginal title over your property after you purchase it, your title insurance may very well deny the claim, leaving you completely exposed. Construction financing is already adapting, with lenders now demanding costly legal opinions and proof of DRIPA-compliant consultation before advancing draws, costs that will invariably be passed through as higher unit prices, further eroding affordability. As legal scholar Dwight Newman rightly noted, the DRIPA ruling means the courts are now modifying the interpretation of all British Columbia law, a change that affects every single sector, from mining to real estate. The appeals process and legislative response will stretch across years. The government is appealing the Cowichan ruling and preparing amendments to DRIPA. Until those amendments pass, the December court decision stands. Every government permit and decision is subject to UNDRIP evaluation. The path ahead is one of unprecedented legal and economic turmoil. If you want to avoid being caught in this generational legal uncertainty, losing potentially tens or hundreds of thousands of dollars on a property that looks safe but carries hidden legal risk, I put together a free guide that breaks down the 7 critical mistakes that will destroy your home investment. The guide covers how to vet title insurance, perform due diligence on land claims, and structure financing contingencies when the regulations change mid-project.